asked you. Do you remember? Did y'all talk about it before? All right. Ms. Rivers, don't see on the call. That's the court reporter. You make sure she's plugged in and we can get rolling.
Yes, sir.
While we're waiting for Ms. Rivers, and we'll get all this on the record, but first of all, good afternoon, Mr. Dill. Mr. Lewis, my recollection is that what remained for us to cover was basically the ineffective piece, which is why I'm assuming Ms. Feely is on the call. But it's something where you wanted to have Mr. Dill here because he might testify after Ms. Feely testifies to share with me his recollection of the nature of the lawyer-client interaction. Is that sort of what's left, or were there other grounds you plan to explore as well?
No, sir, the court is absolutely correct. The court graciously granted a continuance for Mr. Dill to be here in person so that we could address the two enumerations that are remaining.
Okay, sounds good. All right, and it looks like Ms. Rivers has joined us. Good afternoon, Ms. Rivers.
Good afternoon, Judge. I apologize. I'm thinking 2:30.
Yeah, I was thinking 2:30 as well. I think that's when the motion to suppress was listed, but we slid Mr. Dill's motion for new trial in at 1. You're here now. We're good to go. I was late, so you're not. It's not like we've been waiting 30 minutes for you. We've been mostly waiting on me. But I appreciate you plugging in.
Okay, great. Thank you.
All right, so let's get on the record. This is 22SC181085. It's State versus Carlos Dill. Mr. Dill was convicted of the murder of Mr. Stafford after trial and sentenced accordingly. Mr. Lewis represents Mr. Dill on appeal for purposes of the motion for new trial and presumably the direct appeal if the motion for new trial is denied. And Ms. Eaglin, who is with us and who I will put on the screen, is the appellate counsel for the state, for the district attorney's office. We had a hearing in December of last year, December 16th, where we covered argument on the juror issue. We had a juror who engaged a witness, and there's been argument made that it was error not to excuse that juror. And then we talked about insufficient evidence. But there were two ineffective assistance claims concerning late disclosure of a text and the level of preparation that was engaged in, that I believe we reserved so that we could get Ms. Feely here, who is on, and I will add her as well. And anything else, Mr. Lewis, you had wanted to cover today? Mr. Dill is in court. He is not appearing remotely from a Department of Corrections location. And I think we're ready to go unless there's anything procedurally you want to get on the record first, Mr. Lewis.
No, sir. Just one question. Would the court prefer me to be at the podium?
Whatever's easier for you. Because everyone's virtual, you may want to stay right there. As long as you're near a microphone that has a green light on it, Ms. Rivers can hear you, and you've got one right where you are, and there's one at the podium. Some lawyers like to stand. I like you to be comfortable. So wherever you'd like to be, I will also add your camera. And if you'll rotate the screen a little bit so that you're on the screen as well, it's just so that Ms. Rivers can see you while you're talking. If you prefer to be right there, we'll do it that way.
Yes,
does that work?
Yes.
Ms. Eaglin, good afternoon.
Good afternoon, Judge.
Do you have anything you want to get on the record before Mr. Lewis does what he's going to do?
No, Your Honor.
Okay, then we'll get started. We've got Ms. Feely here. If you want to have her sworn in, we can do that. But if there's anything you wanted to say up front, I'm happy to hear that.
No, Your Honor, we can go direct into the direct examination.
Okay. Deputy, if you wouldn't mind swearing Ms. Feely in, either one of you, it's good. Yeah, here, I'll get you. There you go. They can see. I can turn the podium on. Let me hold on one second. There we go.
Raise your right hand. Do you swear or affirm the testimony about to give the courts is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Go ahead and state and spell your first and last name for the record.
Lee Feely, F as in Frank, E-E-L-E-Y.
You're up.
Thank you. Attorney Feely, how are you?
I'm well. How are you doing?
Good, thank you. I wanted to ask you first, Attorney Feely, were you part of the representation team for Mr. Carlos Dill?
Yes.
Okay. And if you could tell me, were there any other attorneys that were involved in this case? On the defense side, I'm sorry.
My trial partner at the time was Lacey Wood. I don't think she was super involved, but I do believe, if I recall correctly, she sat second on that trial.
Okay. And Attorney Feely, can you tell me what year were you barred?
2009.
And during the course of your representation of Mr. Dill, approximately how many capital cases had you tried at that point?
Maybe 15 as first chair, and then some other ones just helping out.
Okay. And if you could tell me what percentage of your practice was criminal law at that time?
100%.
Okay. And have you always been employed by the public defender's office?
I've always been employed by a public defender's office.
So there have been more than one county that you've been involved in?
Yes, sir.
Okay. Now, when you represented Mr. Dill, at what point did your representation commence? At what point in the process? I'm sorry.
So I started with Fulton County in May of 2022, and I believe Mr. Dill's case predated that. So, and I think he might have also been in the Department of Corrections. So I got his case physical file, but at that point I was coming into a caseload where we were kind of triaging, I think I've said before, what would go to trial first. And so I can't say that starting in May of 22, I focused heavily on Mr. Dill's case because I did try other cases in 2022 and 2023. But I would say by the end of 2022, I was pretty plugged in with Mr. Dill's case.
Okay.
And I'll just take judicial notice of the fact Ms. Feely filed her entry of appearance in July of 2022. So prior to that, she wasn't even the official lawyer of record. So that's when she was at least officially involved with the case.
Thank you, Your Honor. Attorney Feely, by the time that you had the case, I'm assuming that the case at that point had been indicted. Is that correct?
Yes.
Okay. So you weren't privy to a preliminary hearing transcript or a preliminary hearing live testimony that you would have seen?
That's correct.
When you let me ask this question. For the purpose of this hearing, were you given anything or do you have anything that you're utilizing to refresh your recollection?
Not at this time. I reviewed the filings.
Understand?
When you say you reviewed the filings, does that mean you reviewed the trial transcript or you reviewed things that you would have filed like a motion to suppress or something like that?
I just reviewed the appellate filings from both sides.
Got it. So the motion for new trial, amended motion, state's response.
Right.
Okay.
And Ms. Feely, did you receive an email from me concerning the transcripts in this case?
Yes.
Okay. And did you get a chance to review those transcripts?
I was able to cursorily, I didn't read every word, but I think I was able to pinpoint what you needed me to focus on.
Yes, ma'am. And after, I understand it was just a cursory review, is there anything that was reflected in the transcripts that to your knowledge did not actually happen at trial?
Not that I recall, no.
Right. Do you remember approximately how many times did you visit Mr. Dill prior to the actual trial?
I still have that case file, so I don't have my notes from when I would have visited him. I do remember he was in Department of Corrections for part of the time that I represented him, and so he wasn't where I could readily visit him.
All right. Did you make contact with him prior to, while he was in, I guess, custody, prior to him actually being transported to Fulton County?
If I did, it would have just been a phone call or a breakout room in a Zoom session.
Now, I understand that you may not remember exactly how many times that you saw Mr. Dill. If I told you that it was approximately 2 times, would that sound correct or incorrect based on sort of your modus operandi in representing capital clients?
It would have been more than that.
It would have been more than that. Okay. And would that also be reflected in sort of the jail visitation system?
So I think that the jail visitation system is not always accurate with putting in every visit, but I'm not going to say that it was like 20 times. I think it could have been a few times that they didn't put my visit in there, but I don't, again, have the file to refer to my notes about the visitation.
I understand. And do you remember providing Mr. Dill with the discovery material?
I remember reviewing materials with him. I don't know what all I provided, probably a police report, definitely the indictment.
All right. Do you know if you were able to view the video, because this case relied a lot on video testimony. Were you able to review any of that video testimony with Mr. Dill?
I remember reviewing that in the holding cell at the courthouse. I don't remember specifically if I went to the jail with a laptop in this particular case, but I do remember showing it both to his family and to Mr. Dill.
Would that be a video of the actual shooting itself?
So there was 2 videos of, I guess, the incident. One of them was a further out angle, and I'm not even sure if it was admitted at trial, but it showed kind of where he was in relation to where the people walking were and then the pursuit. I definitely showed him that one. And then the one that was used at trial, I got later, but I believe I showed him that one as well.
Understood. Now, in representing Mr. Dill, do you remember what the basic trial strategy was prior to actually going to trial?
So we did, because of the video, we were a little bit limited in what we could, with a straight face, argue to a jury. So we discussed some self-defense because Mr. Dill was, in fact, himself injured in the incident. He was shot. And then the manslaughter, I think I requested during the charge conference or maybe a little before.
So at some point, the self-defense claim was dropped. Is that correct? Sort of that theory of the defense was dropped.
Right.
Okay. And was it also a theory of the defense that, in fact, the mens rea, they proffered that Mr. Dill was stalking Miss Willis Riley, and part of your defense was that in fact, there was no stalking. In fact, there was communication between Mr. Dill and Ms. Willis Riley that was in fact initiated by Ms. Willis Riley. Is that also correct?
I believe so, yes.
Okay. Now, in determining that, let me ask you this. Was that defense presented or changed during trial, or did you focus on that defense prior to trial?
I think we talked about the defense prior to trial. That was the game plan going in, and then we kind of pivoted mid-trial.
Right. Was the decision for Mr. Dill not to testify, was that made prior to the trial, or was that made during the trial, if you can remember?
So my recollection, because there's, some clients who definitely like early on, that as you move towards trial, they want to testify. And then there's clients who definitely do not. And then there's clients who, maybe it's a game time decision kind of thing. And so my recollection from Mr. Dill is we didn't believe that he could add anything by testifying, and he did not seem interested, if I recall correctly, in testifying. But it kind of happened organically over multiple conversations.
And Attorney Feely, have you ever had occasion in representing defendants that you would actually go through a sample cross-examination?
Yes.
In this particular case, did you do that?
I don't believe so, no.
And was that because the decision to testify was made prior to going to trial?
As far as I remember, yes.
Right. And as such, then, you would have relied then both on the testimony of the state's witness, but you also would have relied on evidence that you had prior to the trial. Is that also correct?
Yes.
Okay. One of those was Defense Exhibit 1. Do you remember Defense Exhibit 1?
Yes.
And who provided you with that? First of all, can you just identify what Defense Exhibit 1 was?
I don't remember the exact contents, but it was a text message screenshot from one of the witnesses, the main female witness, to Mr. Dill.
Right.
I believe it was Instagram or something like that.
And did this evidence suggest that Ms. Willis Riley had actually contacted Mr. Dill?
I believe so, yes.
And was this consistent with your theory of defense?
Yes.
Okay. And given that Mr. Dill did not testify and the choice was made prior to trial, Defense Exhibit 1 would have been pretty important because that would have been evidence that was outside of what Mr. Dill would have said or even outside of what Ms. Willis Riley would have said. Is that also correct?
Right.
Okay. How did you receive, if you can remember, how did you receive that information?
It was in the file when I got it.
Right. So this wasn't something that his mother gave you or Mr. Dill gave you?
Not me personally. In hindsight, I think I thought we were all working from the same world of discovery. And I can't even say for sure that the prior defense attorney didn't give it to the prior ADA. I just know that's what I got. And I unfortunately erroneously assumed that it was part of all the dumps and everything that I had received in discovery.
All right. Now, and let's sort of get to that point. At some point during the course of the trial, you sought to introduce Defense Exhibit 1. Is that also correct?
Yes.
Do you remember at what point in the trial you sought to introduce that evidence?
It was not through that witness. It was through a later witness. I don't recall her name though.
Would that have been toward the latter part of the state's presentation of their case?
Yes.
Okay. And when you sought to introduce that evidence, the state objected to that, correct?
Yes.
And do you remember what the basis of that objection was?
So Miss Willingham was also, I don't think she was the original ADA on the case. And so it was her presentation to the court that had not been turned over. And I didn't have any evidence to affirmatively say that somebody prior to me had turned it over. And I knew that I had erroneously thought that we were working with the same evidence. So it was failure to disclose it timely.
Understood. And Attorney Feely, the court at some point basically did not allow that exhibit to come in and sustained the state's objection to that evidence, correct?
Yes,
Once that was done, did you seek to bid a continuance?
I did not.
And did you ask the court for leave so that the state could possibly review that evidence and present evidence and rebuttal if necessary?
I did not.
Can I ask you why you did not do that?
I do not have a strategic reason for not doing that.
One thing, Attorney Feely, that you noted, and just correct me if I'm wrong, in responding to the court's assertion as to whether this was willful, whether this was negligent, essentially you admit that it was ineffective for you to fail to either disclose or fail to provide to make sure that information was sent over to the district attorney's office. Is that correct?
I don't know that it's for me to necessarily make the call if it was ineffective, but I can say that it was not intentional. And so it was an oversight on my part. So it was certainly a shortcoming.
And I'm reading from what was provided. This is the certified copy of the transcript. And just correct me if I'm wrong. I'm on page 41. This is volume 3. This is I believe the volume that I actually forwarded to you. And I'm looking at page 41 and I'm looking at line 22 through 25. And I'm going to read this to you. And I want you to just tell me if this is in fact what you said. You said, so it's my position that it was ineffective of me to not make sure that they had every single message from this phone, and that is their sorry, what was his phone. And since I did not do that, I'm just making sure to preserve the record, the inevitable ineffective claim. Do you remember saying that?
I remember saying words to that effect, yes.
All right. And so in responding to the court, you in effect concede that there was some issue of ineffective that you knew was probably going to come up, and you actually conceded that you were ineffective in those lines, correct?
Yes, sir.
Right. Now, you also go on to talk about whether it's harmless error. And I understand that it's the court that actually makes that decision. But you talk about the prejudice of the inability to present that evidence. And if you could explain, if you can remember, or if you just in your own words, why that evidence was so important to be introduced, and the failure to do so would have not been harmless error in your mind.
I think you touched on it because it contradicted the state's theory that it was Mr. Dill initiating all contact and getting nothing back from his significant other, the witness at the time. And so we were going with that theory that he was provoked through, she was actually contacting him during the relevant period of time.
Yes, and Attorney Feely, we only have a couple of more questions for you.
I want to interrupt real briefly.
Yes, sir.
Did we make part of the record Defense Exhibit 1? I know it wasn't admitted, it was excluded at my ruling upon the state's objection, but is it also part of the record?
I believe it is part of the record, Judge.
Good, okay.
Yes, sir. Attorney Feely, once the court, do you remember whether the court addressed whether Mr. Dill would testify at the same time that he addressed the issue of Defense Exhibit 1?
Like in terms of?
Just the chronological order of that. So the court would normally ask any defendant whether they intend to testify, would tell them the colloquy concerning their right to or not to, or what happened if they do testify. Do you remember if that was done close in time to when the court made its decision?
I believe it would have been close in time because that was one of the state's last witnesses.
All right. And once the court actually denied Defense Exhibit 1 coming into evidence, did you go back and ask Mr. Dill again if he wanted to testify, given the fact that you would no longer have that evidence in place?
I did not.
Okay. And do you have a strategic reason why that was not done?
No, sir.
Right.
But just so I'm following your line of reasoning here, Ms. Feely may not have, but you're not suggesting, and it'll be in the transcript, Mr. Lewis, that this incident of excluding Defense Exhibit 1 occurred after Mr. Dill and I had the conversation. You're just making a record that Ms. Feely and Mr. Dill did not have another conversation about testifying before I then engaged Mr. Dill to say, hey, you can testify if you want to. There just apparently wasn't an intervening, let me talk to you one more time, this exhibit's not coming in, so X, Y, Z.
The court is correct.
Okay,
I have no further questions of Ms. Feely.
all right. Ms. Eaglin, questions for Ms. Feely?
Yes, Your Honor, briefly. Excuse me in advance for the sniffles. I am a little under the weather. Good afternoon, Ms. Feely. How are you doing today?
I'm doing well. How are you, other than the sniffles?
Doing well, thank you. I will do my best to not be repetitive, but I do want to ask you some general questions about your background. You testified that you were admitted to practice law in 2009, correct?
Yes.
Are you admitted in any other states?
No, ma'am.
And you also testified that your nature of practice at the time was criminal, correct?
Yes.
And you had tried roughly 15 cases as first chair, correct?
I had tried more than that as first chair. I thought his question was capital cases, but
Okay, that's fair. How many cases had you tried in totality at that point?
the best estimate that I've been able to come up with by 2023 was probably around 50 as first chair.
Okay, and how many of those cases, just an estimate is fine, was a verdict reached?
I don't tend to count them unless a verdict was reached, but I would say probably 90% maybe.
Okay. And you testified that Fulton was not the first PD's office that you were in, correct?
Correct.
What other offices have you been with?
I was with DeKalb County for 10 years, and before that I was up in North Georgia in the Conasauga Circuit for 3 years.
Okay, thank you. Have you ever been found, as of date, to have rendered ineffective assistance of counsel in any of those cases?
I don't believe so. I've testified in a lot of motions for new trial. So I don't know every single one, but I don't believe so.
Okay. And it appears from the record that you and Miss Wood were co-counsel, correct?
Yes,
You did testify today that Miss Wood was not heavily involved, correct?
to my recollection, she had her own stuff going on. I don't believe she did any witnesses or anything like that.
Okay, so it would have been you that was solely responsible for filing the motions,
Yes,
turning over discovery,
yes,
reviewing that discovery,
yes,
interviewing witnesses,
yes,
making all of the strategic decisions to include the defense put forward.
yes.
Okay, so can you tell me how Miss Wood, if at all besides sitting, assisted in this case?
Just generally, talking through things during breaks and stuff.
Are you aware if she ever spoke to the defendant about any of the facts in this case?
I don't believe so.
Okay, would you ever have employed her to do something like that? Is that customary for you to do with the second chair?
No.
Okay. I want to talk to you about your preparation in this case. You previously testified that you filed an entry of appearance roughly a
Counsel,
year before the case.
Hold on. I don't think they can hear us.
May I proceed?
I'm gonna send them a text message.
Your Honor.
Yeah, they said the audio went out in court.
Is it Miss Nelson? Are you able to hear me?
let's see, Ms. Feely, Ms. Eaglin, can you hear us?
Is the podium muted?
Yes,
Yes.
Your Honor, I can
Okay.
hear you.
All right. So what was the situation? Just needed to restart the computer?
It seems like it just crashed. So
Okay.
it was just frozen, and I'm not going to get into the bug. But that seems to have been the issue.
All right, done. We're back in action. All right, importantly, Ms. Rivers, can you hear us?
Yes, I can.
Excellent. Thank you, sir, for coming down quickly. You all had a private exchange for a few moments. Ms. Rivers may have been able to hear it, so a record was made, but Mr. Lewis and I were not able to hear it. So I don't remember the last thing. I know you had asked Ms. Feely if she'd ever been found ineffective before. She said she didn't believe so. She's testified a bunch of times at motion for new trial hearing. I don't know how much further beyond that you went. That was my last note, but I hadn't been writing everything down. So you may need to just rewind a little bit because Mr. Dill, Mr. Lewis, and I weren't able to hear it.
Thank you, Your Honor. I believe I had also got through the questions just asking whether or not she was responsible for certain motions and so
Yep.
I can move on past that.
Okay.
I believe it cut out when I was questioning her about her preparation for this particular case. So I will just go back there.
Let's start there. Thank you.
Thank you. Okay, in your preparation for this case, did you investigate the facts?
And I reviewed the discovery. I don't know that I did a lot of independent investigation. I did go visit the scene, and so I could kind of visualize where the cameras were in relation to the parking lot and things of that nature, but I don't recall like an independent investigation fully.
Okay. Do you recall meeting and consulting with the defendant before and during trial?
Yes.
You previously testified that you do not recall how many times you met with him, and that his availability in the DOC was a little difficult for you to have met with him. Is that correct?
Yes, particularly at first. I think eventually maybe the court stepped in, or maybe it didn't quite get to that point, but he ended up at Rice Street where I could visit him more readily.
Okay. Once he got to Rice Street, are you able to provide a number of times that you met with him?
I could have with my file, but I don't have, I had to turn that in when I closed it out. So I would have had notes from each jail visit with dates on them, but I don't have that.
Being that Rice Street is a lot closer, would it be customary for you to meet with a client housed in Rice Street more than 3 times?
I would say generally, yes. I'm not going to say it's specifically with Mr. Dill that I recall specifically that I saw him 5 times or 6 times, but I would expect in general, I would have met with him more than 3 times.
Okay. Did you ever have an opportunity to meet with him in a holding cell when he appeared for hearings?
Yes.
Okay. I believe you previously testified that you recall showing him the videos in this particular case and his family members those videos. When you showed the defendant those videos, I just want to clarify, was that at the Fulton County Courthouse when he would appear for hearings in the holding cell, or was this done like in the open courtroom?
It was in the holding cell.
Okay. Did you have an opportunity to discuss this case in detail with him?
To my recollection, I thought so, yes.
Did you continue to do so throughout trial?
Yes.
What's customary for you?
Am I
All right.
frozen?
This is not on our end. Ms. Eaglin, I don't know if you can hear us, but you
can't hear me again?
Okay, you're back, but you froze for a minute. Your eyes were closed, but you were asking about what's customary for Ms. Feely.
Yes. And I can ask a more direct question. Do you recall discussing the defense strategy in this case with the defendant?
Yes.
Um, do you you testified that you do not recall all of what discovery you provided him, but that you possibly provided him with the police report, correct?
Yes.
Do you recall if at any point in time when you would meet with him in the holding cell outside of the courtroom or actually in court for hearings, would you have discovery with you then?
Yes.
Would you give him an opportunity to go through it?
I would have had my laptop with me, which would have had access to the entire what was turned over or what I had access to from either evidence.com or Dropbox. I don't recall which one.
Do you recall at any of those times allowing him to see that discovery?
Other than the video, I don't remember specifically going over anything on my laptop with him.
Would it be customary for you to do so?
I would think so, or if I didn't provide copies. And sometimes I will mail like some of the paper discovery. I don't remember if I did that in this case, though.
In your experience of trying criminal cases and having multiple clients, is it common for the defendants to want their discovery in jail?
Yes. Depending on, if there's a sensitive nature of the indictment that they wouldn't want people to know about, maybe not. And I've had that situation come up multiple times, but in general, yes, the more information they have, the better.
Okay. I'm going to talk to you a little bit about the defense strategy in this case. You testified that initially it was self-defense. Is that correct?
Yes.
And at some point it shifted. And can you talk to me a little bit more about why it shifted and what that defense was?
I think it's the way the trial ended up playing out, even though Mr. Dill was himself shot, the evidence as it came out it was going to be difficult for us to assert that Mr. Dill wasn't the aggressor. And so at that point, it kind of became trying to get a lesser and not just straight up not guilty.
Do you recall making the argument that there was sufficient provocation, that he was possibly acting out of passion?
I believe so.
At this time, do you feel that that was the most reasonable defense considering the evidence?
Yes.
Okay. Do you recall if the defendant was able to name any helpful witnesses to support this theory?
Not that I recall.
Did he provide any witnesses for you to contact that maybe would have helped support this theory?
Not that I recall.
Okay. You testified today that you had an opportunity to review the post-conviction pleadings in this case, correct?
Yes.
And that would include the amended motion for new trial?
Yes.
And would that include the state's response?
Yes.
Okay, I want to talk to you a little bit about defense exhibit number 1 that was not permitted to be entered at trial. It appears that you testified that you do recall attempting to admit this evidence, correct?
Yes.
And just if you could tell from your recollection, what was defense exhibit number 1?
It was a screenshot of, I believe, Instagram, but some kind of social media back and forth. But I don't recall the content. I don't think it was like a whole page. I think our point was it was her contacting him.
Okay, do you recall the date of the alleged communication in defense exhibit 1?
I thought it was close in time to the incident. I thought it was that day, actually, but it could have been the day before.
So if the record supports that that call was made on November 26, 2021 at 12:30 a.m., would you have reason to dispute that?
No.
All right. Do you recall the date and time of the murder in this case?
Remember it was around the Thanksgiving holiday, and I think it was, it was definitely late at night. I think it was after midnight.
Okay, if the record shows that the murder took place on the exact same date in the early morning hours, would you have reason to dispute that?
No, ma'am.
So it is safe to say that this alleged either call that was made or received was very close in time to the murder in this case, correct?
The shooting, yes.
And I am curious to know your rationale with your defense, how this call would have then helped the defense's theory in this case.
So it was really to kind of muddy the waters that because the state's theory was that it was all coming from Mr. Dill and that he was continuously harassing this person and she was completely against having contact with him. And so it was to show that she in fact did initiate contact with him.
And do you think that this call being made the day that the victim was murdered, arguably within minutes, is something that would have supported the defense's theory that she was reaching out to him prior to the shooting taking place?
Yes, and that kind of supports our theory that he acted out of passion.
Okay. And do you have, or at the time that you attempted or wanted to introduce this evidence, did you have any proof that this call was actually initiated by her and it wasn't like a, an accidental dial?
No, because I unfortunately don't know where exactly I got that because I did think it was part of the discovery.
So it's safe to say that no subpoena for phone records or social media records were ever made to substantiate that this call of this purported screenshot was indeed even placed from Tatiana's phone, correct?
Correct.
All right. Had you introduced Defense Exhibit 1, was your purpose just alone to muddy the waters as you just testified? Was it for impeachment? Can you kind of expand on that a little bit for me?
Yeah, so it was to counter the state's theory that Mr. Dill was the only person of these two parties that was doing the reaching out. And with that, with her contacting him, reaching out to him, it would support our theory that he acted out of passion.
And you testified that you did not serve the state with this evidence because you presumed that they had already received it?
Or that I got it from them. I didn't, unfortunately, think that it was not part of what was already the universe of evidence that we both had access to.
Do you recall if at any point in time the state had access to the defendant's phone?
I don't know. There was a lot of phone evidence that I got and that was already in the file when I got it. So I'm not sure if they had his phone.
Do you recall if that phone evidence was that of Tatiana's?
I don't know.
Okay. Do you believe that this exhibit was material?
I can't say that it wasn't, given that we didn't present much evidence and that could have made a difference with the voluntary versus murder, but I don't want to speculate. That's all I can do.
Okay, you had an opportunity to question Tatiana, correct?
Yes.
Did you question her about this alleged screenshot? Do you recall?
No, I did not.
Can you explain to me why you didn't? Is it because the evidence wasn't permitted?
No, I don't think I tried to get it into her. I think it didn't really come up until later on in the state's presentation.
I'm curious by that answer, if Ms. Willis, I'm blanking on the second half of the hyphenated name,
Riley.
Ms. Willis Riley, if she had testified, I'm recalling that she did repeatedly, that I was not reaching out to Mr. Dill, he was constantly contacting me. Why would the significance of Defense Exhibit 1, in particular, its impeachment impact, why would that not have been apparent at that point, Ms. Feely, as opposed to what I'm understanding you to say is, it really wasn't until pretty late into the state's case that we decided that this might be something that we'd want to use?
I think it was just an error on my part. I should have used it as impeachment when she was on the stand instead of how I tried to use it.
Okay, it's not that you discovered it only later on in the trial. You were aware of Defense 1 at the time Ms. Willis Riley was testifying. It just didn't crystallize in your head to use it as a method of impeachment of her.
Correct.
Okay.
Thank you, Your Honor. Okay, I want to talk to you about your conversations with the defendant in preparation for trial, just a little more. You previously testified that you met with him and you consulted with him before and during trial, and you discussed the case with him. Do you recall talking to him about his right to remain silent?
I don't recall the specific conversation, but generally it kind of comes up early on, and we would have discussed that it can't be held against him if he chose not to testify, that kind of thing. But I can't tell you like what date we had that conversation or anything.
Do you recall having a conversation with him where you advised him of his right to testify?
Not specifically, no.
Is it customary for you to have those conversations with your clients in criminal trials?
Yes.
Do you recall making it clear to the defendant that it was ultimately his decision whether to testify?
Yes. I don't recall specifically like when that conversation happened, but I remember we discussed in some detail, at least, his right to testify.
And is that also customary for you to do so?
Yes.
Okay. At any point in time, you previously testified that the defendant didn't show any interest in testifying. Had he expressed a desire to testify, would you have advised him at that time concerning the facts in this case to do so?
Yes. So if a client wants to testify, whether I think it's a good idea or not, then it is part of my job to prepare him to do so. And so that's where that conversation would have gone.
And just for purposes of the record, whose decision is it to ultimately decide whether to testify in a criminal trial?
The client.
Okay. And just to reiterate again, this was made clear to the defendant?
Yes.
Okay. And just to make clear for the record again, who was it that ultimately made the decision whether or not he testified in this case?
Mr. Dill.
Okay. You also testified that you don't recall, in essence, having a mock trial where you asked him, the defendant, potential cross-examination questions. Was this not done because he had expressed an interest not to testify?
Correct.
Had he expressed an interest to testify, was that something you would have done?
Yes.
Is it customary for you to do so?
Yes.
Okay. I want to briefly speak with you about the juror issue in this case. Do you recall requesting a motion for mistrial
I believe I did. Yes.
as it relates to a potential juror initiating contact with the witness in this case?
Yes.
Do you recall the court questioning that elderly jury outside the presence of the remaining jurors?
Yes.
Do you recall the court admonishing her?
Yes.
Do you recall the court giving the jurors a curative instruction as it concerns their interactions
I
with,
don't,
go ahead, so sorry.
I don't recall the content of the curative instruction, but I do remember that one was given. That was ultimately the decision of the court.
Okay, the record is void of you renewing your motion for mistrial after that curative instruction was given. At the time, did you feel as though that curative instruction was sufficient?
I know, but I don't know why I wouldn't have renewed the motion.
Okay. Those are all of my questions, Your Honor. Thank you, Ms. Feely.
All right, before I turn back to Mr. Lewis to see if he has any redirect, I want to share my screen and you all can let me know if this is the defense exhibit 1 that we're talking about. I've been looking for it. Let me see here.
I located it, Your Honor, on volume 9, I think, of the exhibits.
Yeah, that's, I think, where I just found it. Oh, whoops, darn it, I hit the wrong box. If we go there and share, is that it? It is.
Is that a
It's
question for Ms. Feely or?
It's actually a question for any one of the three of you. It's in the record, and so I just want to make sure I was envisioning initially when it was being discussed an actual exchange between people. But when Ms. Eaglin began asking more questions about could it have been a misdial and this and that, I was remembering more about it. I think this is it. It says defendants 1. I just want to make sure Ms. Feely doesn't remember more to it. This was made part of the record. I excluded it from evidence that the jury would see or hear, be able to take back to the jury room, which is probably why it's in volume 9 of the exhibits. But more importantly, to my questions, if this is the defense 1 we're talking about, it shows that, as I understand it, Ms. Willis Riley's phone dialed Mr. Dill's phone and Mr. Dill didn't answer. In other words, it was a missed call. So it's not, in fact, an exchange they had, but it could be construed as evidence that Ms. Willis Riley was trying to reach out to Mr. Dill. That's my spin on it. I'm not asking you to agree with the spin. I'm asking people to confirm this is the defense 1 we're talking about.
We can confirm, Judge, that is in fact defense exhibit 1.
Got it. Okay. Thank you. Do you have redirect you want to do with Ms. Feely?
There's no redirect, Judge.
Okay. Ms. Feely, thank you so much for your time.
Thank you. Always a pleasure.
You don't mean that, but you say it. All right.
Thanks.
Okay. Mr. Lewis, any other witnesses you want to call?
Your Honor, I would like to call Mr. Dill.
All right, Mr. Dill, I'm gonna have you come on up to the witness stand. Deputies are gonna tell you how to do that, and then they'll swear you in.
And raise your right hand. Use the right hand promise. Testimony shall give you the truth, the whole truth, and nothing but the truth and nothing God.
I do.
And the truth, how it is. And please state and spell your name for the record. Put up, come on. Yeah, stand. State and spell your name for the record.
Carlos Dill Jr.
Can you spell your last name?
Dill.
Thank you, sir.
Judge, may I continue from this?
Sure.
This position?
That's fine.
Mr. Dill, how old are you?
28.
Mr. Dill, can you tell the court how old you were when you went to trial on the case that is at issue today?
I believe I was 26.
And are you a little nervous?
Yes.
Have you ever been to trial prior to this?
No.
You can tell the court, is it in fact true that prior to you being housed at Rice Street, you were actually in the prison system, correct?
Yes.
What was that for?
On parole violation.
So prior to you being taken to Rice Street, were you informed as to who would be representing you?
Yes.
How were you informed of that fact?
Through Zoom. No, it wasn't Zoom. It was a phone call to the prison I was sent to.
And was that phone call from Ms. Feely or someone else?
Miss Feely.
So Ms. Feely was able to communicate, with you, correct?
Yes.
Did that phone call, you don't have to go into the contents of the phone call, but did she talk about the case or was it just, she was just introducing us?
Introducing herself.
Now, at some point, how many conversations before you went to Rice Street did you have with Ms. Feely?
One.
The one that you were just mentioned, correct?
Yes.
Once you actually got to Rice Street, if you can say from the time that you got to Rice Street, was there another attorney that was involved in the case, for example, for a bond hearing or preliminary?
No.
So Ms. Feely represents you the entire time to your knowledge, correct?
Yes.
Now, do you remember approximately how long it took for you to go to trial from the time that you were brought from Riverbend?
8 months.
8 months. In that 8-month period, approximately how many times did you see Ms. Feely?
Twice.
And the first time that you saw Ms. Feely, were you provided with discovery?
No.
When were you provided with discovery?
I'm not sure. I reached out to her multiple times telling her that I didn't have it. So it was some of the discovery coming through mail.
Do you remember if you had the full discovery or did you have, or what pieces of this specifically did you have?
Just the police report and the autopsy report.
Police report and the autopsy.
Yes.
You remember from trial that there were a number of videos that were shown to the jury.
Yes.
You remember if you ever had the opportunity to view those videos?
I viewed it once, where she came out here. She showed it to me here in the holding cell.
Was this a situation where you were already coming to court for something else? I mean, what I mean something else is, you weren't coming to court for trial, you were coming to court for a status hearing.
Correct.
And I think what you said is that during the status hearing, she showed you all of the videos or one of the videos. What did you see?
One of the videos that would be of the shooting.
Just of the shooting.
Yes.
Were you shown any of the other videos?
No.
During the course of when she spoke to you, did you ever see the text message exchanges between yourself, allegedly, and Ms. Willis Wright?
Oh, yes, I did have that with the police report.
So you had the police report as well as the.
Yes.
Now, your mother testified at trial, right?
Yes.
If you could tell the court what role your mother played in communicating between either you and Ms. Ms. Feely, or herself and Ms. Feely.
My mom came in as a witness because she's the one that took me to the hospital.
And did your mother provide any information to Ms. Feely?
Yes.
What information did she provide to Ms. Feely?
There would be the screenshot of the phone call, the missed phone call, and multiple other messages.
Do you know if your mother, what is your mother's name?
Letitia Mahone.
And is she seated in the court?
Yes.
Can you spell her name for the record?
Mitisha Mahone, Mahone.
Thank you.
In what format did she provide text message and phone call exchanges? Did she give a video? Was it paper? How did she do that?
It was paper.
And to your knowledge, did she email it, bring it in person? How would Ms. Feely or someone from her office would have received it?
She handed it to her, one of the court appearance.
Now, do you remember ever discussing the contents of Defense Exhibit 1 with Ms. Feely?
Yes.
And to your knowledge, Did Ms. Feely understand the importance of the text message exchange and what you guys were trying to do at trial?
Not that I recall.
Well, what was your understanding? I think I may be asking the question a little convoluted, so that's my fault. What was your understanding of what the relevance was of Defense Exhibit 1? Why was it important?
To show that she was in contact with me.
In fact, that's what the defense was, is that you guys were actually dating and she was having contact with you. Was that the defense?
Correct.
Was that the defense that was discussed prior to you going to court?
Yes, it was. We did discuss it. I informed her that we were. I had multiple videos and also messages showing me and Tatiana back and forth communicating, and me staying with her.
Now, Mr. Dill, at some point, a decision was made that you were not going to testify. Am I correct?
Correct.
If you can remember, was that decision made prior to trial or prior to, when was that decision made?
I believe that was the day of the jury selection.
That would have been prior to Ms. Feely introducing anything, correct?
Correct.
What was your understanding that instead of you testifying, that this information would come in?
And then
Now, when you were, was it your understanding also that Ms. Feely was going to withdraw the self-defense and instead go forward on voluntary manslaughter? Was that your understanding?
no, I wasn't aware of that.
You were not aware?
No.
So you weren't sure exactly what the defense would have been in the case?
No, sir.
And you've never gone to law school. Do you know what manslaughter is?
I heard of it, but I don't have a good understanding of it.
Did she indicate to you at any point the sentencing range for a voluntary manslaughter? Did you know, if you were convicted, what it is that you would be sentenced to?
No.
But you did understand the sentencing on murder, correct?
Correct.
Now, once Ms. Feely, do you remember the discussion between the court and Ms. Feely regarding Defense Exhibit 1 and whether it would be admitted in evidence or not, and why it was not?
Due to the fact that she tried to bring it up after the witness was gone.
You remember there was also discussion about the fact that it was not disclosed to the state in proper time.
Yes.
Once the court made that determination, did you have another conversation with Ms. Feely at any point as to whether you would testify?
Yeah, she just stated that it wouldn't be best if it would mess me up for appeal if I did testify admitting guilt.
Right. And when was that conversation, if you can remember?
That was in the midst of trial.
That was in the middle of the trial.
Yes.
When Defense Exhibit 1 could not be entered into evidence, did you have any discussions with Ms. Feely about any other additional witnesses or evidence that would have substantiated or provided the same information to the jury?
Yes, we have multiple other evidence to prove my side.
Was any of that presented to your knowledge?
It was presented to Ms. Feely. Yes.
Well, I guess what I'm asking is, did Ms. Feely present any of that evidence that you spoke about to the jury?
No.
Well, let's just go over what are some of the other witnesses that you told Ms. Feely about that were not presented at trial?
There was other messages showing There was a text message showing what Tatiana was stating that she'll have someone come out and do something to me. That was sent to my son, mom.
And that was pretty consistent though with sort of the exchanges that already were going on between Ms. Willis Riley and yourself and other individuals, correct?
Yes.
So that was more of a cooperation. So you have that text message. Were there any other witnesses, like people, that you told Ms. Fieldy about that she did not present?
There was a neighbor that I did state to her when she came out to see me right before trial. But she asked me, did I remember his name and also the apartment out there? And I stated no, I'm not sure if he still lives there because it's been so long ago.
Understood. Now, you said that she came out to see you right before trial. How long before trial did she come to see you?
The first time would have been January 2023. And then the second time was June, right before trial of 2023.
Now, when you say right before trial, how many days before jury selection?
That would have been a day before jury selection.
So that's Sunday, I'm assuming.
Correct.
And so just according to what you remember, you saw her twice. She saw you twice.
Yes.
Once in January, the day before trial.
Yes.
And did you discuss testifying at that time?
I don't recall.
No further questions, Jim.
All right. Ms. Eaglin.
Yes, Your Honor. Hi, Mr. Dill. How are you doing today?
Okay.
Okay, I will try to not be repetitive, but I just want to get some clear answers for the record, okay?
All right.
If there's something that you don't understand that I've asked, please just let me know, okay?
Yes.
Okay, I want to talk to you about your communications with your attorney, Miss Feely. Well, actually, let me ask you this. Do you recall speaking to any other attorneys in the public defender's office regarding your case besides Miss Feely?
No.
Okay. Do you recall, you just testified that you spoke with Miss Feely twice. That's your recollection, correct?
Yes.
And I want to make sure I'm following this correctly. Twice out at the jail, but there was at least one time, you can tell me how many, when you came here
Okay.
and she met with you. How many times would you say you met with Miss Feely here? It might have been right through those doors, but somewhere in the courthouse.
Well, twice at the jail. Here, I'm not sure how many times that I did come here for court. I would say maybe 3, just brief.
But one of them that was long enough that you were able to watch a video and talk about the video? Because I thought you said that was here.
Yes.
Okay. So is that a different time from the 3 that you're describing as brief? Or so it's 4 times here, or one of the 3 was when you saw the video?
One of the 3.
Okay.
Those 2 times that you spoke with her at the jail and the 3 times that you spoke with her here, either in the courtroom or in the holding cell, did she talk to you about the discovery in this case? Meaning the evidence that she was given by the state?
The only thing we can't really discuss was the footage.
Okay.
Meaning the video.
Correct.
And outside of the video, you testified that you also had the police report in this case?
Yes.
And that evidence you received by mailing at the jail, is that correct?
I believe she did bring that to me her first visit.
Okay. In that police report, you also testified that it contained phone calls between you and Miss Riley, correct?
There will be the Instagram messages.
Do you remember it being a lot of paper? Like, was it a lot of documents? The
No,
police report plus those Instagram messages?
no, there wasn't a lot of paper. Just a few sheets.
Okay.
I would
Um,
say maybe 20, 25.
Okay, maybe 25. Okay. You testified that you had reached out to Miss Feely multiple times requesting your discovery, correct?
Yes.
Okay. Um, the times that you would actually see her, did you request what you wanted then?
Yes, I did request it from her, and she stated that she would get it over to me.
What kinds of things did you feel like you didn't have that she did have?
I was just going through the context of the discovery what I did see. I was stating the 911 call, just everything that I needed for my discovery.
Okay, no, and I'm gonna be clear, you're entitled to have as much as can be safely given to you at the jail. But I'm wondering if there's something that you particularly wanted. You mentioned 911 call, but I don't know that there was a whole lot else in the discovery besides autopsy and police report and text messages. Was there something that you thought was in there that Ms. Feely said, oh, I'll get that to you, or other than the 911 call?
No, I asked her for the 911 call and everyone's statement that was showing on my witness list.
Okay.
I never received that.
Do you know that those people gave statements?
I'm not sure.
Okay.
You testified that while in the Fulton County Courthouse, I don't recall if it was in the holding cell or an open court, but you had an opportunity to review the video of the shooting, correct?
Correct.
But you do not recall seeing a second video.
No.
Okay. You also testified that your mom provided these alleged screenshots of missed calls or communications between you and Miss Riley, correct?
Yes.
And that she provided this on paper
Yes.
to Miss Feely at one of the court appearances, correct?
Correct.
Do you recall whether or not you actually looked at the paperwork that your mother provided Miss Feely the day that she provided it?
I
Had you had
did.
an opportunity to look at the paperwork yourself?
Yes.
So your mother gave you the paperwork before giving it to Miss Feely?
No, ma'am. She gave it to Miss Feely, and Miss Feely showed it to me.
Okay. And do you recall discussing these communications with Miss Feely that she had showed you that your mother had given her?
Yes.
And what were those discussions about? Can you tell me like what you all talked about regarding what was given?
Just showing that we were in contact with each other. Just showing that what Tatiana was stating wasn't the truth.
So when you say what Tatiana was stating, this would have been Tatiana after she testified at trial?
No, this was before speaking on the screenshot messages that my mom provided to Miss Feely.
But how do you know when you say these messages showed that what Tatiana was saying wasn't the truth? How did you know what Tatiana was saying?
Police report.
Okay, so this police report included witness statements in it.
Well, just stating where she was stating is.
Okay.
Okay. Do you know if the paperwork that your mother gave to Miss Feely, do you know if she had already received that information from the state?
She did not.
Okay. Is that because these were communications from your phone?
Yes, that could be true, yes.
Okay. Do you recall the phone company that you had at the time? Who your servicer was, like Sprint, Verizon?
I believe it was AT&T.
Okay. And do you recall if Miss Feely ever attempted to get records from AT&T of your phone?
No,
Okay. Was that phone in your your name or your mother's name?
my name.
Okay. Um, do you recall discussing with Miss Feely what your defense would be in this case?
We did discuss self-defense prior to trial.
Do you know if at any point in time that changed?
No, I was unaware.
You were present in the courtroom for the entirety of the trial, correct?
Yes,
So any arguments that Miss Feely made in open court, if there was a change in your defense, you were present for, correct?
correct.
Okay. Did you have concerns about this case that you expressed to Miss Feely?
Yes, I did have concerns.
What kind of concerns?
Um, just stating what would take place and try to just getting a better understanding how it would be during trial.
So, meaning you were unsure about what trial would be like, or you were concerned about it? Yeah, they're two different things. One is it's unknown, and I'm nervous about it. What's it going to be like? But a concern to me is, I think the defense should be, I wasn't there. I have an alibi, and you're saying self-defense, and so we're not agreeing on that.
Unsure.
You're unsure of what it was going to be like. Okay.
Do you feel that she listened to these concerns?
No, no. I don't know.
Were there questions that you would ask her that she would refuse to answer? Or would she answer your, hey, what's it going to be like? And she'd tell you. You might not have liked her answer, but she gave you an answer.
Well, yeah, she did give me an answer. She would answer every question.
Okay.
Okay, you testified that you provided Miss Feely names of people that you thought would be helpful to your case, in particular a neighbor, correct?
Yes.
I'm sorry to interrupt, but I thought your testimony was you didn't remember the guy's name. You knew it was a neighbor, but it had been long enough ago, you didn't remember his name.
That's correct.
Okay.
Sorry, Your Honor, I was getting there.
Oh, okay. Well, I hadn't heard that he provided names so much as the existence of someone.
Sorry, I could have asked that differently. My
Okay.
apologies. Do you know if Miss Feely or her investigative team tried to locate this particular neighbor?
She stated that she went out to the apartment complex, but didn't get in contact with no one.
Was it your understanding that then she tried to get in contact with this neighbor?
That is what she stated, from my understanding.
Okay. And I'm curious to know, in what way do you believe this neighbor's testimony would have been helpful?
It would have helped a lot with Tatiana stating that I never, that I wasn't living there with her. I was. And go ahead.
No, I am so sorry to cut you off. Please finish.
Yes, I was living there with her, and also, he never seen us get into any altercations.
So it's your understanding that he could have testified that you were indeed living with her.
Correct.
Is that something your mother could have testified to as well?
Yes.
Okay. What was the time frame? Do you remember when you lived with Tatiana? Do you remember the dates?
I would say maybe up to November 22nd.
Okay, when you say up to, do you remember maybe the start date?
I would say the end of August of 2021.
When did you meet Tatiana?
I had been knowing her since 9th grade at high school.
Okay, so your first time meeting her wasn't through social media?
No.
Okay, so you had been knowing her since 9th grade.
Yes.
Did you all go to the same school?
Yes.
What school was that?
Washington High School.
Okay. All right. Did you speak with Miss Feely about the benefits, or did you, let me ask it this way, did you talk to her about testifying in this case?
She spoke to me about it. And it wasn't it wasn't, not really, no.
Okay. Did you ever express a desire to testify in this case?
Yes, I had thought about it and mentioned it to her, but just going through everything that was going on, then I stated no.
So then is it safe to say that you all did have a conversation about testifying?
Yes, we did right before trial.
And who made the decision that you would not testify?
When she stated that if admitting guilt or anything with that nature, it will kind of mess me up on appeal process, if anything.
So it was your understanding that she advised you not to testify, correct?
Yes,
But who made the ultimate decision on whether you would testify?
I did.
Do you recall having conversations with the judge in this case, the Honorable McBurney, that we're speaking with today, about whether or not you had a desire to testify?
Yes,
And do you recall the judge making clear that it was your choice to testify?
yes.
Okay. Tell me why you didn't want to testify in this case.
I just answered that.
I didn't understand it, so I need you to explain it again. That, oh, it was you were concerned that you might say some things that were close to admitting guilt, and that would be a problem with the jury or maybe on appeal.
Yes.
Okay, I don't mean to put words in your mouth, but I'm remembering you said something along those lines?
Yes.
Okay.
Okay. At any point in time, do you remember communicating to the court that you were not satisfied with Miss Feely's services?
No.
Were you satisfied with her services?
I was just going along with the process.
But the question is, as you think back on the things that Ms. Feely did for you or didn't do for you, are you satisfied with the work she did on your behalf, getting ready for trial and, more importantly, doing the trial?
No.
And why is that?
Due to the fact that the evidence that we provided her with, she never was able to admit that.
And the evidence you're talking about would be whatever information your mom gave her, the printouts of texts and things like that.
Yes, and the lack of communicating with me.
What would communicating with you more have done for her in terms of defending your case?
She would have had a better understanding of the case. I'm not sure if she did really look into the case. If she had time to look into the case.
What part of the case do you think she didn't understand? I mean, there's a video. So what part of the case do you think she didn't understand?
My side of the story.
Okay.
I just want to make the record clear, the screenshots that you say your mom brought to Miss Feely of communications with you and Miss Riley, you said that this was immediately before trial. Like when did she turn that over to Miss Feely?
I'm not sure which court appearance it was.
Do you recall if it was before trial started? Was it during trial?
It was before trial.
Do you remember if it was like a long time before trial? Was it right before trial? If you can't recall, it's okay, but
It may have been, I'm not sure the exact day. That it would have been the week before when we did state that we was ready for trial, I think.
okay. Alrighty, no further questions, Your Honor. Thank you, Mr. Dill.
Mr. Lewis, any redirect of your client?
There's no redirection.
All right. Mr. Dill, if you'd step down and go back to where Mr. Lewis is. Mr. Lewis, any other witnesses?
There are no other witnesses, Judge.
All right. Ms. Eaglin, any witnesses from the state?
No, Your Honor.
All right, then the evidence is closed. Mr. Lewis, any argument you want to make beyond what is in your amended motion for new trial?
No, Your Honor, I believe that everything that I would be arguing is within the briefing, so we would just submit it based on that.
All right. Ms. Eaglin, anything you want to add?
The state is prepared to rest on its brief. I would like to state that I think it would have been more appropriate to bring in Mr. Dill's mother to maybe have discussions about these alleged communications that she somehow was able to retrieve and gave to Miss Feely. It wasn't something that was brought up when Miss Feely was being questioned on direct, and so it wasn't really something I had an opportunity to question her about on cross, because I didn't know that this was something that had even occurred.
Before you say a whole lot more, a couple observations. One, while Ms. Mahone has been in court, so she's heard everything that was testified to, you could always call her. But number two, we could always get Ms. Feely back. My guess is she is at her desk and she has not been on the Zoom call. If you have a chance to present evidence, and so calling Ms. Feely to explore with her, because I have the same curiosity you do, is like, well, what's your recollection of your client's mom handing you a sheaf of documents, and when did that happen, if it happened, and did you consider them and whatnot? But that's if you want to explore that, that's for you to do. Mr. Lewis has made clear he's put up his part of the case.
I think just as the law is, it was a proffer that the defense would have been required to make in this regard. Kind of instead of just the kind of conclusory arguments surrounding these alleged documents. According to Mr. Dill's testimony, these documents were allegedly given maybe 1 week prior to trial, which, if that is indeed the case, I would assume would also be in violation of the discovery, being that disclosure usually has to occur at least 10 days before trial. And so there can be an argument made there. I'm happy to recall Ms. Feely if the court would like to know whether or not this communication indeed happened, where these documents were turned over, and whether or not it was possibly something Miss Feely had already received from the state. I will defer to the court on that, but
I'm not providing any guidance. I'm not going to call her as a court's witness. So if you're not asking for more time to do that, I'm fine with that as well. I just was responding to your concern that this is not your word and this is not what happened, but that there was some surprise or ambush. Like, gosh, if I had known that there was this vector of information coming in, I would have asked Ms. Feely about it. I'm not suggesting, Mr. Lewis, you did anything like that. But the way this rolled out, I could understand why you might say, guess what? We do need to call a witness. I'm not calling a witness. I am deferring to you to make the record you think that needs to be made. And I'm familiar with the case law as well about how a defendant would need to prove up the impact of a piece of evidence or a witness who didn't testify. So I just didn't want you to think that because you didn't provide a witness list or didn't say, hey, I'm going to be calling a witness as well, that you're precluded from doing that.
Thank you, Your Honor. I do think, in light of the testimony that has come out today from Mr. Dill, that it would be important to speak with Ms. Feely just briefly about whether she has any recollection of this occurring, just to clarify the record and provide as much information for purposes of appeal if necessary, if it gets there.
Okay. What I'd like to say, well, Mr. Lewis had stood up. You want to add something?
Your Honor, the only thing that I was going to add, and I was going to probably do it in argument if the state wasn't going to call Ms. Feely, but what the defense was resting on, and we were going to ask the court to refer to, is the actual motion by the state to exclude. And that's in the record. And if the court will review that, Ms. Feely explains in her response as to why she didn't turn it over, is that she actually believed that it came from the state. And if that's the case, it couldn't have been given by my client the week of, because she had already had that discovery. So Judge, I was just going to tell the court that we are resting on the record of volume 3, approximately page 41, where Ms. Feely actually goes into detail as to why she did not present the evidence, why she didn't turn the evidence over to the state. She believed that the information actually came from the state.
But from your recollection of that exchange that Ms. Feely and I had, and then Ms. Willingham, about excluding defense 1, did Ms. Feely ever say, oh, and by the way, some of this I received from my client's mother pretty recently, so I couldn't have given it to you earlier?
She did not mention that, Judge.
Okay. All right. Let me see. Oh, yes. Yes, please, Ms. Hansberry. Ms. Hansberry is going to see if we can get Ms. Feely back on. It should take 2 minutes for both sides to do whatever they need to do. And if we can't, then my question to you, Mr. Lewis, would be, well, one, I have no doubt we could get Ms. Feely here in the next 24 to 48 hours, which means we could keep Mr. Dill here. But if he is anxious to get back, because people don't always like being at Rice Street, then it would be you and Mr. Dill talking about the fact that when we are able to get Ms. Feely back, he'd just be appearing virtually like he did with the first part of the hearing.
Yes, sir. And I can tell you right now what Mr. Dill's preference is. He wishes to get back as soon as he can, sua sponte.
Amen.
And we would have no objection if we needed to proceed at a different time to do so by Zoom.
Okay. Well, let's give everyone 2 minutes to see if Ms. Feely is still literally sitting at her desk. She was connecting with us from her desk. She can pop back on. If she's already left for the day or she's out at the jail or whatever, then we'll need to pick a different time. But we don't need to rush it because Mr. Dill's preference would be to rush back to, what facility are you at?
Hancock.
Hancock. Get you back to Hancock. Where is that?
Slaughter, Georgia.
Where is that?
East.
East? Okay. Okay. Way out there, like by Lake Oconee? Oh, okay, right. So it is, it's on the sort of backside. Got it. All right, let's see what we hear from Ms. Feely. Sounds like she'll be getting back on. We're working through Ms. Wood, her trial partner, for Mr. Dill's trial to get to Ms. Feely.
Say snowfall backgrounds.
All right, it does not look like we're going to be able to track Ms. Feely down right now. So what we'll do is figure out a time when you can be with us, Mr. Lewis, and I think you could appear virtually for this as well. I'm envisioning this being about 5 minutes, but a not unimportant 5 minutes. So I think scheduling shouldn't be too complicated. We just need to make sure we know where Mr. Dill is for that, so he can hear what Ms. Feely has to say about it. And so if for some reason he's in transit, we'll have to bump it past that. I'm anxious to close it out now while it's fresh. Ms. Feely will remember less and less of what she reviewed at your request the further we get from today. So ideally, we'll squeeze it in this week at some point. That doesn't mean, Mr. Dill, I'm going to keep you at Rice Street. We will let the sheriff know that you can be returned on the next available transport. And I don't know how it works. I suspect you go through Jackson. I think all buses go to Jackson. And then you'd go from there back to Hancock, but don't quote me on that. I don't know how it works. So anything, Ms. Eaglin, procedurally from the state?
No, Your Honor.
All right, Mr. Lewis, anything else?
No, sir.
All right, appreciate your work on the case. Do you have any questions for me, Mr. Dill?
No, sir.
Okay, I'll tell you a little bit more about what to expect when this part is over, once we wrap it up with Ms. Feely. Okay. All right. Thanks, everyone.
I'll let you know.
Thank you.